Good evening, everyone. Welcome to the Immigration Talk Show brought to you by Sakshi TV. My name is Ranjit. We are here today with the attorney Prashanthi Reddy to discuss the latest updates on immigration about the L1 visa, and followed by a Q&A session. You can call the numbers displayed on the screen and ask any question related to immigration, and the attorney will be glad to answer. We'll start taking calls in few minutes. Before that, I would like to repeat the disclaimer. Please note this show does not provide any legal advice. It is general in nature and it is only for informational purposes. Sakshi TV news and agents are not responsible in any way for your actions. Use this information at your own risk. Hi Prashanthi garu, how are you doing?
Hello. How are you, Ranjit?
I'm good. So yeah, this week, we'll talk about the L1 visa. That's a topic. So let's start with, what is an L1 visa and there are two types in L1, I believe. So could you please shed some light on what is L1, what is the nature of L1B, and how long is it valid, and what forms need to be filled?
Yeah, sure. So basically, today's topic is L1, which is basically an intra-company transferee. It's L1 is often used in lieu of a H1. In many instances, multinational companies, MNCs, prefer to use L1s because there's no H1B quota. There's no quota on L1s, unlike H1s. So H1s, and also, so they can file at any time. It's not like they have to wait until March every year to file and then, be subject to the cap. So, and also the other advantage of L1 is there's no prevailing wage in an L1, so you can really pay any reasonable wage, and that should be fine. So oftentimes L1s, employers can get away by paying a lower wage than they would pay a H1. So that's the big advantage of using an L1 in lieu of, the H1. But just to go back to your question, an L1 is an intra-company transferee, which means basically an employee from a foreign company is being transferred to the US company in order to either set up operations if it's a new entity, or to take care of the operations. So basically, one part of the company in a different country is transferring their employee to another country. And the reason they usually do that is because, unlike, for the L1, it can be presumed that the employee has some specialized knowledge, some knowledge of the maybe how the company operates, the product. So obviously not anyone can take that person's place. So they can't obviously employ a US citizen to do the same job, because then they wouldn't have any knowledge of company product or the sales or whatever it might be, the unique knowledge, or maybe the processes. So I guess that's the reason they came up with this L1 visa to start off with. Now, in order for an L1 to be filed,
Q&A session has started.
There has to be a parent company abroad, a company abroad, and a company in the US. Now, and there has to be a relationship between the two companies, the US and the foreign company. And that relationship is defined. It has to be either a parent and subsidiary relationship, or it has to be a branch, or it has to be an affiliate. An affiliate pretty much means one of the two subsidiaries, and both of them are owned by a third company. Or they are both of them are controlled by a third entity. That's an affiliate. So that plus the employee should have been working as a multinational executive. Should have been working in an executive position in the foreign company for at least 1 year. And usually the requirements for an executive position are not only that they don't do clerical work, and they have other people that they supervise. So these are the requirements. And they're basically taking care of policy, budget, executive type work, not clerical, picking up the phones, making sales calls. So there's a certain type of work that executives do, and it's basically they have to be part of the policy and decision-making team, and they should also have supervisory duties. So these are the things. One, that there should be a relationship between the two companies, either affiliate, a subsidiary, or a parent. So basically, a parent is if the US company, if the foreign company is a parent, that means the US company should be owned completely by the parent company, by the foreign company, or it should own at least a controlling share in the US company. Then it's a parent. And a subsidiary is the company that is owned, that at least is owned by a parent and at least 50% or more controlling share again, or all the shares are owned by the parent, or all the shares are owned by the owners of the parent company. So, it could be any of these relationships. I hope that's clear. Again, parent and subsidiary. So parent-subsidiary relationship, or the two companies have to be affiliates of each other, which means that a third entity owns them. Or they could be branch offices, which means an operating division or an office of the same organization just housed in a different location. So these are the different legal relationships that can be had in an L1. So that, and basically an L1 is given for 7 years if it's an L1A. Right now we're only talking about L1As, which are multinational executives. So they're given for 7 years, and you can file for. There's no labor certification requirement, which means it's an easy path to a green card. So you can file for an I-140 directly after 1 year of being in the US on an L1. So these are some of the requirements, what a L1 basically means.
Okay, sounds good. So what forms are used, like, for H1B, I-129 is used to file an H1B. So is it similar kind of form that's used for the L1A, or, are they directly applied consulate?
Yeah, no, you actually have to apply for, if you're doing just the regular L1A, you have to actually apply in the USCIS here. And it's the same form as a H1. It's the I-129 form. But when for H1 you use I-129 H supplement, the additional form, here you use the L supplement. So it's the supplement form is different, but the basic I-129 form is the same. And unlike the H1, there is no LCA requirement. There's no LCA that has to be filed. And because as I said, there's no prevailing wage or set wages that have to be given for an L1A. But it of course helps that if a higher wage is given, that is one way of showing that it's a higher executive position. If you're giving a lower wage, then USCIS might question what the level of the position is if they're not getting, a wage that is usually given to executives. It's possible. So that's what it is, Ranjit.
And how about the fee, Prashanthi Garu? Is it same as like H1, depending on the number of employees and all?
No, so they don't have that 1,500. That fee, the basic fee is the same, 460, I believe, is the USCIS fee. But other than that, they don't have all the other. They have the 500 fee, which is the fee for, if it's not an extension, then you have to pay additional 500. But that's it. That's the fee. So it's much less than a H1B.
Okay, sounds good. We'll take a call and then we'll continue with our section. The caller number ending 0779.
Hi Prashanthi, this is Pallavi.
Hi.
I have a question regarding H1B. On this year, February 2020, I have filed extension and amendment with one specific client. After that, I got an RFE in the month of April in between, and we have replied to them to the May saying, providing all the required documents and all. My H1B validity ended in August 1st. So far, I have waited for the USCIS, but they did not given any update. So again, my employer has raised a request and asked them to look after my file. Again, on the September 28th, I got an RFE, again one more RFE, asking that to show the status and the proof that I have been maintaining. The thing is, the USCIS has approached to my client. They had given the joining date when on the day where my interview was taken. So USCIS is telling that is a mismatch of dates. So I got an RFE saying make the status, maintaining the status, pay stubs, weekly activity, everything they asked me to provide. But unfortunately, I lost my job due to the pandemic after the RFE has given. So right now, to maintain the status, what should I provide them? Like whether I need to provide the same client details saying I have been worked so far on the same thing, or weekly activities and everything. So because I did not have job right now due to pandemic, I did not got another offer also. Now I am in bench, so how should I respond to them and convey the time sheets or weekly activities, whatever proofs to maintain to them?
So if you have an RFE, second RFE, and depending on what they're asking for, and if you have said in the H1 that your work site is the client site, but you no longer have that work, then I don't know on what basis you're going to respond to the RFE, because the entire H1 has been filed based on work at the end client site, right?
Yes, correct.
So you can't really
So how to respond to that RFE?
You cannot respond. You have to withdraw it because there is no longer work there. So the LCA is no longer valid, which means your H1 is, the H1 petition that you filed is no longer valid. Did you file for a change of status from an F to a H?
No, because the thing is already my H1 validity got expired on August 1st, 2020.
So this is an extension that you filed?
Amendment.
Is this an extension that you filed? Okay. So your I-94 has already expired. And
yes, correct.
So my suggestion is that while this H1 is pending, the only way to do it is delay in responding to the RFE, and while the H1, this RFE is pending, file for another H1. And then hopefully based on the bridging, they will, approve the second H1, or you have to file for a change of status right now to a B2 if you don't have a project, so that you can maintain status. But the only thing you need to prove is that as of the date of filing, the project was there. So my suggestion is immediately, if you don't have a project, then immediately file for a B2. If you have a project, immediately file for a H1 again, based on the receipt, based on the pending application. If you don't have, file for a change of status to a B2 based on the pending application, based on the receipt. And then once you get a project, then again file a change of status from a B2 to H1, and you're not subject to the cap because you're previously on a H1. And when the time comes to respond to the RFE, remember you have a 60 days grace even after the time to respond because of COVID. So when the time comes to respond, then you just have to respond saying that the project was, at the time that we filed, it was there, and this is proof to show that when we filed, the case was a bona fide case. But after that, the project got over, and therefore we are not able to provide you with the information that you're requesting. Remember, it's important to show that as of the date of filing, it was a bona fide project, because that will help you with your bridging. When you file the change of status to a B2, they won't say that, it was a frivolous case that you filed, and therefore there is no bridge created. You have to prove that it was not a frivolous case. So that's the best option you have.
Okay, but December 24, 2020 is RFE response date. As there is a
So you
60
can
days grace,
postpone it to 60
I can
days.
wait. Yeah, till February 24th, I can wait.
Right.
So
Until then,
what is the best
before
way?
that,
Like,
make sure you either file a change of status or, another H1 based on this receipt,
okay.
a transfer.
Without job, can I do that, or do I
No, you
need to
cannot.
get the job and
No, your
then
employer has to be able to show that you have some kind of job for them.
Okay, sure. Thank you, Prashanthi. Thank you for
You're
your
welcome.
time.
Bye.
Thank you.
Okay. Okay, let's continue with our discussion and then we can take another question later. What is the minimum? Is there any requirement for L1A like H1B, like degree requirement or the experience apart from you said they have to be working with the same company in India, I mean, whatever the transfer. So is there any time limit that they have to work like 1 year or 2 years minimum, or, as soon as they join the company, they can come over here? Any such restriction?
Yeah, so you should have been working as an executive in the foreign company, which has a relationship with the US company. Remember, we talked about the relationships. And you have to be working there at least for 1 year before you can qualify for an L1. So you have to show 1 year that you work there, 365 days.
How about the requirements, like education requirement, like H1B? Do they need to have a 4-year bachelor degree?
So there is no
bachelor
educational requirement. It's not a specialty occupation. It's not about positions that require an advanced degree or a bachelor's degree. It's all about whether they have duties that are that of an executive or not. That is the main thing that is looked at here. And they look at the relationship to see if the relationship exists between the two companies, and they look at to see whether he previously also held an executive level position in the foreign company or not. Those are the only requirements.
Okay. Coming to the next question, unlike H1B, which the dependents of the H1B cannot work unless there is an I-140, is it the same case with L1, or the dependents can work?
So for the L2, unlike the H4 EAD, which came with a lot of controversy and prerequisites, when the L1 was instituted, and they also had work visa for L2s. So an L2 can file an EAD, is allowed to file EAD and work. So there's no such requirement that I-140 has to be approved or no prerequisites. As long as the person is on a valid L2, they can file for an EAD and they can start working on an L2.
Okay, sounds good. So they can just file an L2 EAD without any I-140 or anything.
Correct.
Okay, another question here is, what is the process of getting green for them? I heard it's very easy, and as you also were saying, there is no need of any labor certification as well. They can directly file, I believe, I-140. Is there any requirement for that? Again, like as you said, like L1B doesn't have any, L1A doesn't have any requirements of education, you said. So is it same with the green card, and can you just walk through the process?
Yeah, so that's EB1C. Basically, you're filing an EB1 petition. So that's the big draw, right, for being on an L1 and then filing a green card based on that. So 1 year after you've been on an L1, if you're here in the country, you can apply for for an I-140. There's no need to test the labor market, so there's no need to file a labor cert. And the other biggest advantage is you're not EB2 or EB3, but you're actually EB1. It's a completely separate category, EB1 multinational executives. So the only requirement is that they should have worked for a period of 1 year before they qualify for the EB1. And you could show that you worked in the foreign company also for 1 year. It doesn't have to be in the US company, which means that you can come to the US directly on an EB1. You don't have to actually come on a L1 and then work for 1 year in the US and then file for an EB1. You can file directly also from abroad for EB1. So that's the big draw for a lot of people who work as multinational executives. Unlike, on a H1 where the EB2 and EB3 waits are several years, EB1 is much, much, much better. And for other countries, it's immediate, it's current most of the time. So that's the big advantage of it. Again, the requirement is otherwise the same as an L1. You have to show that you have been working in an executive level position. You have to show, even for an L1, you have to show that you're supervising at least 2 other levels of people under you. For example, if you're a director, then maybe you are supervising a marketing person, and you are then, there's another tier below that, which is marketing executives. You have to show that you're supervising 2 levels of professional positions, which means in simple language, positions that require a bachelor's degree, right? So if you can show that, the 2 tiers, and if you can show that, for example, if you are joining a company, or rather you are coming to the US to join the branch, or if it's a branch office of a parent company, then, and they have no employees here at all. If it's a startup, it's fine. You can show a business plan. You can show that they intend to hire a manager, a HR person, an accounts person, even if it's a small company. And you can show that that intention is there, and you submit a business plan. That this is the plan for hiring personnel, and this is the plan for finances. So just because, so it doesn't, if it's a startup, you don't have to already have ready-made employees, but you can show that you intend to hire them. So that's another way of doing it. So it's important to show employees in an L1 position. So for example, there are many instances in which there are huge companies doing millions of dollars of business, especially the jewelry business, just to give you an example. But they don't hire many employees because it's a very close-knit, high stake, and you have to have a lot of confidence in the person that you're hiring, because it's all jewels and diamonds. So it's a high trust position, so they don't hire many people. So oftentimes they'll have net worth of millions of dollars, but they may have only 1 or 2 employees. And in that case, to file an L1 becomes difficult, because you're not able to show that this person will supervise, 2 other levels of people. In that case, then you have to show that you cannot show the person is doing, then who picks up the phones, right? Who takes the calls, who takes messages. You cannot show that the executive person is doing executive work as well as clerical work. They have to be doing only executive work. So you have to show that someone is doing this, even if it's part-time. There is another person who's picking up the calls and who's, taking messages, making sales calls, etc., etc. And you can show, even if you're not able to show that the L1 employee is supervising 2 other levels of people, you should at least be able to show that it's a functional manager. There are 2 ways of doing it. And one is by proving that he's a functional manager, which means that he has specialized knowledge, and the duties he's performing are executive. But even though he's not supervising anybody, could be one way of showing it is that he's supervising people abroad, because nowadays with remote work, a lot of the functions are done outsourced. So you can even show that he's supervising someone outside the country, from the parent company, or you can show that he is a functional manager and his position and his duties are such that they cannot be performed by anyone else, because he has that unique knowledge of the product or processes of the company that other people don't have. So that's one way of overcoming that lack of employees, but it's hard, but it can be done. So yeah, I hope that answers your question, Ranjit.
Yep. We'll take one caller and then we'll continue with our discussion. Number ending 6419. Number ending 6419. Hello.
Hello, this is Manohar.
Yeah, please go ahead.
1897. 1897.
Yeah, you're on the air. Please go ahead.
Yeah.
Hello.
My name is Sambaya. I'm working in a temple. I came on R1 visa, sir. My visa expires by May 31st. How much time to file for green card, sir? Is there any time limitation?
Well, while you're in status, you have to file your 360, I-360 and the 485.
Due to this
You
pandemic
are required to be in status.
situation.
So while you're still on an R1, you should file it.
Okay. So, madam, if you applies, how much time it takes, madam, for getting green card?
Again, that is under a separate category, EB4, I believe. So depending on what the processing time is, the 360 processing time they're going to take into consideration, which I believe is a few months. And then you can file adjustment of status if your visa number is available at that time, depending on whenever you're filing. So look at the visa bulletin, see if your visa number is available. Then it's just again processing time for the green card, which is 12 to 18 months. So
Okay.
remember, you only need to be in status when you file. Once you file the application, you can let your R1 lapse. But remember, if the 360 gets denied or the 485 gets denied, then you fall out of status if you don't have an R1 non-immigrant status. And then you have to leave the country. And then,
thank you, ma'am.
Yeah.
Madam, if I have the B1, is it possible to stay here, madam, after completion of the time?
You can file for a change of status to a B1.
Okay.
Yes, you can. But then filing a green card is a different story.
Because, I'm having the B1 visa also, but I came here on R1 only. Is it there any possibilities to stay after
so if you don't
completion
want
of
to
my
leave the country,
visa time?
then you have to file for a change of status to a B1.
Okay, ma'am. Thank you, ma'am. Thank you.
Okay, yeah. Another question coming here. What are the documentation requirements for the L1 application?
There are quite a few documents, and again, these are the so you need to show US company documents, and you need to show documents from the parent company as well. So you have to be able to show that both the US company as well as the foreign company are have bona fide businesses, and so that has to be proved. You can't just make a statement and say, it's a bona fide business. In order to show that they're both bona fide businesses, you need basically their copy of their lease, where they're operating from, for both parent as well as US company, their tax returns, their contracts, invoices, whatever, to show volume of business, whatever you can show, contracts, invoices, client letters, whatever you have. Also, to show that actual office space exists. In addition to lease, you also would need utility bills. If you own the space, then you need to show property documents, and then to showcase your product as to what you're selling or what services you're offering. You might want to print out the website and put in the website printouts or brochures, or put in photos of the office, bills of lading, airway bills, if that's applicable. And in addition to that, you want to show, if it's a new company, and I was talking about this, if it's a startup, you want to submit a business plan from the US company to show that you do intend to employ XYZ employees, and you need to show then a future organizational chart, a proposed organizational chart. If you are an already established company, then you will already have an org chart, and there's a requirement, as I said, that the L1 has to supervise two levels of personnel. So you have to show that as well. You have to show his name and then the personnel that he's supervising in the org chart. And in order to show that the two levels that he's supervising are professional positions, you'll have to give the job description of each of the employees that he's supervising. and their educational qualifications as well. And then in order to show that there's a relationship between the parent and the foreign company, right? You have to show that there's some kind of relationship between the two companies. You have to show the certificate of incorporation and the share certificates. Main thing is the certificate of incorporation for both the US and the foreign companies, just to show that the company is registered and it exists. But the share certificates will tell you what the ownership of the company is and will show the relationship between the two companies. For example, if the Indian company is a parent company and the US company is a subsidiary, then all the shares of the US company will be in the name of the parent company. And that's how you prove that it's a parent and subsidiary relationship, just to give you an example. So those are the documents. Also, you will show maybe how you got the seed money, how you got the startup capital. And perhaps you got that from the parent company and in the form of a wire transfer or money coming into your bank account. So you'll have to show the bank statements to show that those funds as to how that money came in. The repatriation or the wire transfer, whatever it might be, proof of funds. Then, of course, as I said, bank statements to show that, and also bank statements to show that your company is financially sound and you have enough money to operate at least. I mean, so the starting capital, if it is a startup, should be enough. There is no minimum or maximum amount, but it should be enough for you to at least operate for 3 to 6 months. Enough to give your down payment for your office space, to pay your employees the first few months of operation, and take care of utilities, etc. So whatever that money might be, you have to show that as money that is available in the bank. And it's a good idea to show that that has come from the parent, from the foreign company, as I was saying earlier. Also, you have to prove, remember, that the executive worked as in an executive level position in the foreign company as well. So then letter from the foreign company showing what the duties of the person were. And also your pay stubs from the foreign company and your tax returns showing that you worked there for at least a year. That's another requirement, right? So you have to document every requirement that there is, the L1 requirement. So that's what we're doing here, documenting every single requirement. So those are some of the documents that are required, and some of them are common. For example, to show viability of both the company's tax returns, lease, etc., brochure, org chart from the parent company also, because you have to show that he previously worked as an executive. So these are some of the documents that are required for an L1.
Okay, Prashanthi Garu. So another question here. There are two visas in L1, like L1A and L1B. Are they both same or are they different? If different, how are they different actually?
So an L1A is a multinational executive. And an L1B is a person of specialized knowledge. So completely different actually. An L1B is not someone working in an executive position. What the company is saying is we are transferring him from our foreign entity to our US entity because he has specialized knowledge of our product or our processes. That's an L1B. So if you see most of these MNCs, they use L1B in lieu of H1. And the way they justify this is generally they'll say that, okay, from the past 1 year, they have been working with client XYZ on this project. So they have unique knowledge of the product. And for us to hire someone else and teach them about the environment and the product is going to take time. Therefore, that's why the L1B was instituted. But they have to prove it, that the person actually qualifies for an L1B. And in order to file an L1B, you have to show that there is something unique in the company's product or processes. For example, you're using some kind of a technology or software which is unique. It doesn't have to be proprietary, but it has to be somewhat unique. which means that it doesn't have to be, if it's proprietary, that's great, because then it's difficult to show that anybody else will have that knowledge. But it has to be something at least that is not easily, if you're using CMM, in the past years, they would say that that was a particular process, CMM process. And that was not very commonly, the knowledge, it wasn't known commonly. So you'd have to get a certification to, get knowledge on those processes. So they would use that and twist it and say that, we're using these processes, but we have modified it in a certain way, and we're using a modified version of it. And this beneficiary has that unique skill and has actually worked on these processes, and therefore we need them to come here and work with our client in the US. Or you can say that they worked previously with the same client, but now they're physical, they have to be physically present in the US at their client site, and therefore, we need them to come here. So the good thing about the L1B is they can work at the client site. They don't have to necessarily work at the company office. They can work anywhere. And as I was saying to you, that there's no salary requirement, minimum or maximum. So a lot of MNCs use these L1Bs. And the other good thing about the L1B is blanket petitions can be filed. Provided that certain requirements are met, a company can apply for a L1 blanket petition. And what happens with that blanket petition is then each time they have to bring someone in, they don't have to apply with USCIS. They don't have to file an I-129. They have to go directly to the consulate and fill out the I-129 petition and everything, but they have to just take it to the consulate, and the consulate will decide whether this person qualifies for an L1B or not, and they're allowed into the country. So it becomes much, much easier when you don't have to go through USCIS and you're going directly to the consulate. So, but in order to qualify for a blanket, there are certain requirements that have to be met. So basically, the first thing is, of course, the relationship has to exist. A parent, branch, subsidiary, affiliate. It has to be a qualifying organization. Both the companies have to be qualifying organizations, and then the petitioner and each of its entities are engaged in commercial trade or services. So they're into a certain business. And then the petitioner has an office in the United States that has been doing business for 1 year or more. So that's important. That is not a requirement for the L1A. It can be a startup, but for an L1B, you have to show that the US office has been open for at least a year. And then the third requirement is that the US office, the petitioner, has 3 or more domestic and foreign branches or subsidiaries or affiliates. That means they should have 3 other entities around the world. This cannot be the only organization. This organization, of course, the foreign organization has to be there, the parent. But in addition to that, they have to have 2 more organizations. Branches in other countries, I guess, would suffice, or affiliates or subsidiaries, whatever it might be. They have to have 3 other organizations. And then most importantly, the petitioner, the US company, and the other qualifying organization has obtained approval of at least 10 L1B petitions. So first you have to file 10 L1B petitions, and they have to get approved. Then you qualify for a blanket, otherwise you don't. So and that has to be done between the previous 12 months. So it's quite a stringent requirement, and that's why only big companies can usually qualify for blankets. And more importantly, the combined annual sales has to be 25 million. And US workforce, 25 million, or a US workforce of at least 1,000 employees. So as you can see, small businesses will not qualify for L1 blanket. They can do L1B individual applications and of course L1A applications. But for blanket, you have to be a large organization. So that's the story with the blankets. And you have to remember the L1 blanket is usually more difficult to get approved, especially if you're filing an individual case when compared to the L1A, because to prove specialized knowledge is always more difficult.
Got it. Before we get into it, I just want to tell the viewers that if you want to reach the attorney Prashanthi Garu for private consultation, please reach at 212-354-1010 or prashanthi@reddyesq.com. I would again like to repeat the disclaimer that please note this show does not provide any legal advice. It is general in nature and it is only for information purposes. Sakshi TV news and agents are not responsible in any way for your actions. Please use the information at your own risk. Yes, Prashanthi Garu. Next question is, how about the L1A extension? So do they get 2-year, 3-year or 1 year? How does it work? Or it's again officer's discretion?
So that's a good question. If your US organization is not a startup, but has been in business, then you initially itself, the initial application is for 3 years. You get 3 years. But if it is a startup, then the initial application you only get for 1 year. And then you have to file a 3-year extension, just like the H1. And then you get another 3-year extension. So totally you get 7. If it's a startup, initially you get 1. If it's not a startup and it has been in business for at least a year, then you get directly 3 years and you can apply for another 3 years and then another 1 year. We are presuming in the interim, people will file the green card because after 1 year after filing the L1, you qualify for the I-140.
Okay, and unlike H1B, they can stay a maximum of 7 years, I believe, right? Instead of 6.
Correct, yes. But for the L1B, Ranjit, it's only 5 years. But for the L1A, it's 7 years.
Oh, okay. And next question is, can they transfer on L1 to another company? How does it work in the US? Let's say if there is a requirement, there's no requirement anymore and they got terminated or for whatever reason or something happened, will they be able to transfer to other organization? What are the options they have?
Yeah, so if you want to transfer to another organization, you'd have to most probably file a change of status to a H1. And you might be subject to the cap. So that's the only way to transfer or move to another company while you're in the US. On the other hand, if you want to file for another L1, then you'll have to leave the country. Remember, the requirement is that you should have worked for the foreign organization for at least a year. So you'll have to leave the country, work for that foreign organization, foreign entity for at least a year, and then again come back through that entity on an L1. So that's the only way of doing it if you want to stay on an L1. But you can't transfer to a different L1 company L1 within the US because that 1 year requirement won't be met.
So they cannot transfer to another company on L1. What are the options do they have? So let's say if they have filed an I-140 and they are, let's say, in the stage of already having an EAD, or let's say they are about to get an EAD and it's past 6 months. So at that point, can they transfer an AC-21 or even that's not possible?
So the AC-21 regulation applies only to H1s, I think. I don't think it applies to L1s, but I will cross-check for you and we can talk about that at the next session. But generally, all the AC-21 regulations with reference to portability, transfer, and I think I'm correct with this, apply only to H1 and doesn't apply to L1. So in an L1 situation, you're pretty much out of luck and you can't transfer to another company with the 485. But the good thing is that you don't have to wait for years and years, right? On an L1, especially an L1A. Yes, L1, L2, when we'll talk about that later, but I mean, L1B is a different story, but L1A is EB1. So the wait is really not that long for them. So usually it works out. They can, of course, change status to a H1, which a lot of people do, because a lot of MNCs don't file green cards. So they change status to a H1 and then they go through the regular process of filing, the I-140, 485, etc., and use the AC-21 provisions to move after 6 months on the I-140 is approved. But with reference to the L1B, it's a different story because L1B you cannot apply for, it's not EB1. You have to file a labor cert and it's EB2 or EB3. So that's a long wait. So people on L1B are usually not happy because neither do they have the portability provisions of a H1, and nor do is their processing time, commensurate with an EB1 because it's EB2 or EB3. So most L1Bs would rather, I think, change to a H1 because it's kind of difficult to stay for years and years with the same company on an L1B.
Got it. Okay, how about this? I believe they don't need to go through labor certification and all and the PERM, so directly they would be applying I-140. Do they have premium, or they don't have premium for L1A I-140?
That keeps changing, and I don't know presently whether they have premium or not. I have to look at the list, but it keeps changing. Like any premium processing, H1s sometimes have premiums. I-140s sometimes don't have premium at all. So that keeps changing. EB1 I-140s sometimes have premium, sometimes don't. So I don't know what the state of affairs is right now, but we'll have to check the list to see whether right now premium is there or not. But in the past, there has been premium for I-140. And that includes not just multinational executives, but they've had premium for I-140 EB1s in exceptional ability and extraordinary ability as well, and national interest waivers as well. So that keeps
I believe
changing.
national interest waiver does not have.
Every few months it changes. So you have to always make sure you look at what the present state of affairs is.
So yeah, approximately how long will it take to get a green card for these multinational executives in your knowledge? Right now it's current, I believe. Usually, I believe it's definitely faster than other EB1, EB2, EB3. But what's the usual time frame?
Well, if you don't look at the visa number availability, and let's presume that the visa numbers are current, then they're only looking at processing time, which is the processing time for an I-140, which if you have premium processing now is not 2 weeks anymore, but is 30 days. And then you're looking at processing time for the 485, which is, 12 to 18 months is the processing time. So that is the time period taken. Of course, the I-140 might take longer because even if you do premium processing, there might be an RFE. A lot of EB1 cases, I-140s get RFE'd. So you can expect an RFE. And usually they're a little complicated. So you can expect that will take, additional time for you to respond as well as for them to process it. So, that you can add another 1 month. So maybe there's no RFE about a month. If you do premium processing, if there is an RFE, you can add a month or two to it. So 2 to 3 months, I would say. And if you're not doing premium processing, then maybe 4 to 6 months for the I-140 to get approved.
Okay, let's say when they file the adjustment of status, they can usually they can file most likely concurrent because most of the times they are current. Let's say they are filed concurrently. Is it same like the H1B? They can stay in the country even if the L1 status are expired or L1 visa is expired?
Right. Any 485 you file, it gives you status. It gives you temporary status, allows you to stay in the country, allows you to travel, and allows you to, meaning get advanced parole, that's a visa, and allows you to get EAD, allows you to work. So once you file the 485, you are pretty much in status. You don't have to maintain your non-immigrant status if you don't want to.
So, okay, how about the EADs for L1As? Is it like same usual, like 1 year or 2 years again, or do they have any special thing with the EADs?
Again, it's the same thing. You get 1 year extensions on your EADs, and it usually takes 6 months for them to process the EAD. You can apply 6 months in advance rather, and it might take them 6 months or longer, or usually it takes 1 to 3 months, but nowadays EADs are taking longer. So give it 6 months and apply, you're allowed to apply 6 months in advance. So I would say apply as soon as you can. Just because, biometrics are an issue now, and EAD card production is an issue because of, lack of USCIS pretty much mismanaged their independent contractors, and they don't have anyone producing cards right now. So, or there's a shortage. So apply as soon as you can.
Okay, can you, I mean, now we have discussed about L1A, the green card process and all. Is it same with the L1B? I believe they are not, they don't come under EB1, right? So what process or path they have to follow towards the green card?
So they have to file a labor certification like any person who's on a H1 would file. And then they have to, depending on what their job requirements are. So if their job requires a bachelor's plus 5 years or a master's with or without experience, then it would be EB2. They would be able to file in the EB2 category, which is the advanced degree category. If their requirement is a bachelor's with 2 years of experience or less than that, then they would be required to file under the EB3 category. And so the visa numbers, as we all know, are retrogressed. So it's the same as the H1. They would file a labor cert, test the job market, see if any US citizens or permanent residents are available for the job. If not available, then if no resumes come in, or if they're able to disqualify the resumes, then you would file the actual perm, the labor cert, after doing all the ads and doing the recruitment process. And then, of course, you would file the I-140, and depending on whatever they qualify, you can, if they qualify for EB2, you can still file for EB3. You can downgrade, but you cannot go up high at a higher level. You can go to a level below. That's up to the employer what they choose to file as. So if you qualify for EB2, you can file for EB3. That's what the famous downgrading is. But you cannot file for EB1, so that you can't go up, you can go lower. So they would file for an I-140, and once their visa number becomes available, they would file for 485. They could also file if they're working in an area and they're working, for example, in the IT sector or in the business sector, they have achieved something in their professional career, and it is unusual, and they've received awards, etc. Then they could also do EB2 national interest waiver. Then they don't need the employer to support their I-140. They can do it even if their employer is not willing to support it. They can file a national interest waiver. That's only useful if the employer is not willing to do the green card. Otherwise, it's not really useful because the priority date is the same for national interest waiver EB2 versus a regular EB2. So these are the ways in which an L1B can get a green card, pretty much the same as a H1.
Okay, so is this the same thing as like the H1B, like having an I-140 will give them unlimited extensions?
So as I said, the AC21 regulations don't apply to L1s.
Oh, okay.
In that sense. Applies only to H1. So all this portability and extensions, etc., apply only to the H1B category specifically.
Oh, that's the reason most of the L1s prefer going on to the H1B if they are maxing out. They try to.
Right, they transfer, a lot of them transfer to H1.
Okay. Now moving on to, a little different topic. We have a couple of questions from offline regarding the I-485 thing. So a lot of people, we are getting offline questions that I-485, when they are filing along with the dependents, they are getting the I-485 receipts with priority date. There's a mismatch of the priority date. Let's say husband and wife has their own I-140. They both filed based on husband's dates, but then when they receive the I-485 receipt, they have their priority date on that. Is that going to be an issue? So will that need to be corrected?
Yeah, definitely. It will be an issue. So it has to be corrected ASAP. So the lockbox or service center has to be contacted depending on where the receipt came from. And the priority date has to be fixed. Otherwise, they will not get their green card when they're supposed to. Oftentimes we know that there is, when in a husband and wife situation, if the wife belongs to a different country, then the wife's, even though she's dependent, the wife's priority date can be used. That's a different issue than from what you're saying. But, I just thought I'll mention that as well, that cross-country, you can do that and, and get a green card faster. But if it's an issue of both having I-140s, and most probably when you filed the 485, you included both the I-140s, and USCIS got confused and used the, because usually for the 944 or the public access form, we have to we have to submit the dependents I-140 also if they have one. So when you end up doing that, maybe the officer will get confused and use the wife's priority date instead of, use the dependent's priority date instead of the primary applicant's priority date. And that can cause confusion and slow down your processing time significantly. So make sure that it gets corrected.
One last question before we wind up the show. Few people were saying that, when they file I-485 along with the I-131 and I-765, and for some reason I-765 got rejected because of using a wrong fee amount or checkbox, or, for whatever the reasons. So now I-485, they have the receipt. When they are filing the I-131 or I-765 later, not along with the I-485, will they have to pay the fees, or they are exempt from the fees because I-485
no,
is already pending?
They have to pay the fee. The only time that they're exempt is they file it concurrently with the 485. And Ranjit, another thing I wanted to mention, and I was thinking of mentioning it and I forget, there is an update. I'm hearing that there's a lot of scams going on with reference to immigration. So people are getting emails, and other attorneys have told me that people are getting emails supposedly from USCIS saying that they have not updated their AR11, and one person has supposedly paid 130,000, and I have no idea why they paid, to a treasury account. We don't know where this account is, and then he realized that it was fraudulent. But the emails look very real. I've seen the emails. They have a picture of USCIS logo. It says USCIS. There's a case number. They have the person's passport information. They have the person's A number. So it looks very authentic, and I don't know how they're getting this information, obviously, but there's a lot of scammers out there, and they hack into accounts and get this information. So please make sure that you speak to your attorney and not correspond directly with the USCIS, especially if it is an issue of money or giving any information. They might ask for your social security number. They might ask for funds, whatever it might be. There is a scam. So please be careful with this.
Yeah, everyone, please be aware. Yeah, please be aware. Don't pay money for anyone. I think we are towards the end of the show. Thanks for all the calls and watching the show. It was a great session with interesting topics and questions. Please call in every Wednesday at 5:30 p.m. EST to watch the Immigration Talk Show. Again, it's every Wednesday at 5:30 p.m. EST on Sakshi TV. This is Ranjit signing off. Thanks, Prashanthi.
Thank you. Bye.